Okay. So in Unit 5, we have something called as writs. Okay. Now, what is writ? Writ is nothing but order of the court or a direction. Okay. It is giving some order, passing some order, or it is giving some directions to another court that you need to do something or you need to stop doing something. Okay. That is nothing but a writ. When we talk about Constitution of India, it empowers Supreme Court as well as High Courts to issue such writs. Under Article 32, Supreme Court is given power. Under Article 226, High Court is given the power. Okay, constitutional remedies that a citizen can seek directly from the Supreme Court. If our fundamental rights are violated, we can directly go to the Supreme Court and file a case against such violations. Like state is having a responsibility, right? Under Article 12, whatever is considered as a state, different departments, all the different bodies, corporations, if some fundamental right is violated, we can directly go to Supreme Court, file a case for enforcement of our right. That is Article 226 of the Constitution. Same ways, okay, same ways under Article 226 of the Constitution, we can move to the concerned High Court for violations of any other provision of the Constitution, including the fundamental rights. For fundamental rights also you can go to High Court, but you have a right to directly go to Supreme Court also. And for other provisions that are there in Constitution, you need to first go to the High Court. Now, why I am mentioning concerned High Court? If your right was violated by some department of Karnataka, you need to go to Karnataka High Court. If it was violated by some department of Punjab, you need to go to Punjab and Haryana High Court. Okay, like that, wherever your right was violated, you would go to that particular court for enforcement of your rights. So both Supreme Court as well as High Court is having writ jurisdiction. Other subordinate courts do not have it, like Magistrate Court, Sessions Court, Civil Court. These are not having this power. Okay.
Yes, ma'am.
Now, when we talk about writ, there are 5 different types of writs that we have, and this provision is mentioned, or the types are given under Article 32. What are these different types and what does all these different types of writs mean? You need to remember that part. Okay, so there are 5 different types of writs that we see. 5 different types of writs. First one is habeas corpus, mendemus, prohibition, certiorari, and quo warranto. These are the 5 different types of writs which we have. Depending on how our right was being violated, we would seek that specific writ only. Okay, whatever is applicable, we would go for that particular writ only. Now, what are these different types of writs and how are they different from one another? When you listen to these words, you feel like, what are these names all about, right? So all these names are having one meaning, and if you remember that meaning, it becomes easier for you to remember it. Okay, so what is the meaning? I will try to underline it. Habeas corpus means you have the body. Okay, so it's a Latin term which means you have the body. Now, many times it may happen that a person is arrested. Okay, when a person is arrested, there are certain things which need to be followed. He needs to be informed the ground of his arrest. He needs to be told that, okay, you can consult a lawyer, you can inform some family members. He needs to be produced before the nearest magistrate, right? So if that does not happen, okay, when a person is arrested, it has to happen in a certain direction. If that does not happen, if that is not being followed, writ of habeas corpus may be filed, which is you have the body. That produce this person before us, or whoever has arrested this person, produce that person before us, and we want to ask him, why has he arrested or detained this person? Okay, court would ask him a question. So this type of writ is used in cases of illegal detention and imprisonment. A person is kept in prison, a person is detained, and it is illegal detention. There is no valid reason why he was being arrested, but he was still arrested. In such a case, court would ask that you produce the person or whoever has arrested. Court would ask that this police officer, you need to come before the court and answer our questions. Why have you arrested this person? Why have you detained this person? Or why you failed to produce him before the nearest magistrate within 24 hours. Okay, court would ask that. This writ allows the court to direct the detainer to appear before the court and to give a valid reason for imprisonment and detention. Court may ask the police officer that you come before us and you tell why have you arrested this person. You give us your points, right? Why have you arrested? You give us justification. They must provide proof that it is legal. If police officer has arrested the person, police officer is having a liability to show before the court that yes, this is the reason why I have arrested this person and this is how it is legal. Thus, the onus of proof, the responsibility of proving is on the detainer. Detainer is the police officer or the person who has arrested, right? That person is having a responsibility to prove it before the court that the ground of arrest is proper only. If the court finds that the person has been illegally detained, if court feels that no, this ground is not proper, it's illegal, it's violating a law, he was not produced before magistrate within 24 hours, and he was simply kept in prison or lockup. In such cases, court can order the detainee or prisoner to be set free. That this ground is not proper, you release this person. Like that also court may say. Okay, we have this particular case, Sheila versus State of Maharashtra, where the court explained that it's not necessary that the detainee, as in whoever is arrested, whoever is kept in the prison, right, should be the petitioner. It's not necessary that whoever is arrested, that person should file the case, that person should be a petitioner. An interested party who has some connection with the case may also do so. Some other person might also file the case, maybe his relative, some public interested person, whoever it is, that does not matter. What matters is somebody was illegally arrested and kept in custody. That is what matters. Okay. Is it clear, habeas corpus?
Yes, ma'am.
So you need to remember this thing, then it becomes easy. Otherwise, you may feel like, what is habeas corpus? What is Q warranto? So if you remember it, right, you can remember the entire thing. So you have the body. When you have arrested a person, bring that person or bring the person who has arrested, police officer and things, and tell us why you have arrested this particular person. You give us the reason.
Okay, ma'am.
Okay, now second one we have is Mendemus. Now literal meaning of Mendemus is we command. This is important. We command. Okay, this writ is used by court in order to order public official who has failed to perform his duty or refused to do his duty or to resume his work. Now when we say public official, who is a public official? There are different departments of the government, right? Central government departments, state government departments, and a lot of people are employed there. And they are employed for public benefit, right? To provide us some kind of services, they are being appointed. Take, for example, there is the officer appointed in regional transport office, RTO office, where we would go to apply for our driving license, for our permit, registration certificate, and so many other things, right? So it's a very important office, right? It's for public utility. So many people apply for license, registration certificate, and whatnot. Now, there is a public official in RTO office. RTO is the main person, right? His signature and authorization would be needed. This person is not performing his duties. He is saying that, okay, well, whoever is applying, let them apply. All my subordinate officers would do everything, but I will not do my job. As in his final signature, I'm not giving. In such a case, public is going to suffer, right? They would not get their registration certificate, license, etc. Even though they have fulfilled everything, they are not getting it. And that is not a good thing, right? Public is going to suffer. In such cases, Mendemus may be filed wherein a person goes to the court and says this person is appointed as a RTO officer, regional transport officer, and he is not performing his duties. He is not issuing licenses, registration certificates. Even though we have given all the forms and everything, we have filled on the test and all we have done, all the formalities are done, this person is not issuing the driving license or RC. In such case, court may ask this person that why have you not done your job? Why are you not performing your duty? Or why are you not resuming your work? Okay. So besides public official, Mendemus can be issued against public body, corporation, etc. Like whatever bodies we have seen under definition of Article 12, right? Against all those bodies it may be issued that why are you not performing your duty, as a result of which public at large is suffering. Okay, so here a public duty has to be there and public duty is violated by the person. In such a case, court would say that you need to do this particular thing. You need to issue driving licenses, whoever has applied to you. Same might apply for passport office also, right? You have applied for passport, but they are not simply issuing it. Everything is done from your side. There also Mendemus may be filed. Okay, same ways if you have sought information under Right to Information Act and department is not providing you the information, there also you may file Mendemus. Okay, all these are nothing but when someone is having a public duty and they are not performing this duty. There, court would order, we command, we order you that you perform your public duty. Okay, is it clear or you want another example?
Ma'am, I want another example.
You want another example? Okay, wherever it's not clear, you tell me, okay, because the words sound complicated.
Okay.
Okay. Have you applied for passport?
Yes, ma'am.
You have. Okay. So did you find any difficulty in maybe police verification or something like that?
Not like that, ma'am.
Nothing like that. Okay. All right, then say, take for example, many times it happens that people apply for passport. Okay, maybe they are in a hurry, they need to go somewhere, they need the passport within maybe 1 month, within maybe 15 days. Okay, in such a case, you need to pay some extra money to get it that fast. Okay, the person has paid extra money also, form he has filled, everything is done, but still passport office is not issuing the passport. And they are not giving any reasons also. Simply they are not issuing it. In such cases, what would that person do? He is suffering, right? He is not able to go to the place where he wants to go. He can go to the court and file a case under Mendemus, writ of Mendemus, that I have done everything from my part. Department is not issuing the passport. They have not even given me a reason. In such a case, court will command that person that you are a public officer, you are appointed for the purpose of issuing passport only. So if there is nothing lacking, all the formalities are done, why are you not issuing the passport? Issue it. Like that court may say. Okay, it can apply in a lot of different departments. Like take for example, electricity. Okay, you have constructed a new house. All the formalities, everything is done, you applied for electricity and they are not giving approval, they are not allowing it. In such case also you can file a case that why are they not giving me electricity connection. Okay, it may apply for different matters. For maybe registration of a certain property, it can apply. Okay, electricity connection, water connection, all these different things where you are going to a government department or maybe some tribunal, some kind of a body, corporation, etc. Because they are not doing their job properly, you are suffering. There you would go to the court and court will ask them that you need to perform this certain thing. Is it clear now or is it confusing?
It's clear, ma'am.
Clear, right? Okay. So in this case, State of West Bengal versus Nuruddin, Supreme Court held the writ of Mendemus is a personal action where the respondent has not done the duty they were prescribed to do by law. The performance of duty is the right of applicant. Government has appointed that person to do that duty only, to issue passport, or to issue driving license, to issue registration certificate, etc. If they are not doing that duty, there we can file Mendemus, because it is your right. You can seek for driving license that I'm above 18 years of age. I have passed the driving test also. I have a right to claim for the driving license. If they are not giving it to you, you can file a case for Mendemus. Okay, is it clear?
Yes, ma'am.
Now, next two writs that we have, right? These are a little bit similar. How similar? Because both of these are related to a case, okay, which is filed in the court. A case is filed in the court, and both these writs are relating to that particular case only. First of all, we have prohibition. Okay, prohibition means to forbid, as in to ask that you stop. Okay, stop this, prohibit this, to forbid this. Prohibition, from the name also it's clear, right? To forbid something, to prohibit something. Certiorari means to be certified. To be certified or to be informed. Okay, like telling someone. Okay, like you are informed that your exams might be from May 5th. Right? What is this? University has given you an information that, okay, fine, maybe it's time that you start studying. Any point in time in May, your exams would be conducted. Right? This is nothing but to be informed, to be certified. Maybe registrar has put his signature also that yes, this is something official. You need to start studying. Right? Same thing happens here also. Prohibition and certiorari both are related to a case which is filed in the court. But then why do we need two different writs? How are they different? Prohibition, it applies to a pending case. Okay, case is filed in the court, but finally court has not decided it. It is still pending. Court is still deciding on the case because it takes years altogether to decide a case, right? So prohibition applies where the case is not yet been decided by the court. Okay, where certiorari arises, it applies in case where case was filed in the court and case is finally decided. Court has given its decision also. Court is completed. There certiorari applies. Okay, so prohibition and certiorari both applies in a case. This is for a pending case. This is for a decided case. Okay. Now, what is it?
Yes, ma'am.
The literal meaning of prohibition is to forbid. A court that is higher in position. Now, who can issue a writ? Which court can issue a writ? Under Constitution, who is given writ jurisdiction? Which court? Do you remember? We discussed, right, starting. Which court is having this power?
Wait, no, ma'am.
Which court
Ma'am, the
can issue
Supreme
it?
Court and High Court, I think.
Yes, correct. Supreme Court and High Court can issue a writ, right? Always remember, no lower court, only Supreme Court and High Court. So what is prohibition? Prohibition means to forbid. Okay, a court that is higher in position. Now, when we say higher in position, it mentions Supreme Court and High Court because only these two courts can issue it. Okay, so a court that is higher in position issues a prohibition writ against a court that is lower in position. That means Supreme Court or High Court is issuing writ of prohibition to a lower court. Maybe Sessions Court, maybe District Court, maybe Civil Court, Magistrate Court, whatever court it is. Okay. And what is this doing? To prevent the later, that means to prevent the inferior court from exceeding its jurisdiction, or so see, some jurisdiction would be there, right? Some matters they can decide relating to these kind of matters. They can decide, right, from exceeding its jurisdiction that does not cross. that it does not possess. Okay, so what happens here is lower court is told that why are you taking this kind of a case? You don't have the authority to take this kind of a matter. Okay, whatever power is given to the lower court, it is exceeding that power. It was only told that you only deal with this kind of matters where maximum punishment is 3 years of imprisonment. But it is deciding a case where punishment is 5 years of imprisonment, 7 years of imprisonment. So Supreme Court or High Court would say that why are you taking this matter? Your power is up to 3 years only. Why are you deciding this case where punishment is 5 years or 7 years? You don't have the power. So right now itself, you stop this particular case. Okay, it directs inactive. That means it would say that right now itself, you need to stop this case. It's a pending case. Your power is over. You need to stop it. Okay, is it clear?
Yes, ma'am.
Or is it confusing?
No, it's clear, ma'am.
Okay, so jurisdiction basically means power. Okay, whatever power is given, it is exceeding that power. In such cases, court would say this is not a power given to you. So right now itself you stop because it's a pending case. Okay.
Yes,
in
ma'am.
certiorari, what happens is it is a final case. Case is decided already. After that, only higher court comes to know that something wrong has happened. Okay, wrong is already done. The literal meaning of the writ of certiorari is to be certified or to be informed. This writ is issued by a court higher in authority to a lower court or tribunal. Same again, Supreme Court or High Court would use this writ on a lower court. Either to transfer a case pending with them to itself or quash some orders. Okay, so this usually happens to transfer a case maybe the case is decided, they need to execute it or something. Okay, so to transfer the case to the higher court or to quash order in the case, some decision court has given, higher court would say that you don't have power to give such an order, such a decision, so this decision is invalid. This decision is not going to be applicable. Okay, because you have exceeded your jurisdiction. This power was not given to you. It is issued on the grounds of an excess of jurisdiction or lack of jurisdiction or error of law. Some problem is there. Court exceeded its powers or something happened. Okay, it not only prevents but also cures further mistake in judiciary. Already wrong is committed, right? So it tries to cure. It would say that whatever order was passed, it was by mistake. It's not applicable. All right, is it clear? This is for pending cases. This is for decided cases. Because it's pending, court would say stop it right here. You are exceeding your jurisdiction. Because it's decided, court would inform or court would certify that whatever decision was given, that is not going to be applicable. That's not going to be valid. Okay.
Yes, ma'am.
Now we have two cases here. Kolkata Discount Company Limited versus ITO. The Supreme Court held that when a subordinate court or tribunal is shown decisively that they had acted in excess of their jurisdiction, the court will issue a writ of prohibition regardless of whether there exists an alternative remedy or not. So court is mainly concerned that courts should remain within their jurisdiction. Okay, and court would see that only. What parties would do afterwards, what kind of remedy they would get, those are not like lookouts of the court. Court would mainly care about jurisdiction of the court, okay, exceeding the jurisdiction. For certiorari, again, we have this case where scope of certiorari has been given, that where there is an error of jurisdiction, power was exceeded or something happened, where the court has not given proper time to both the parties. Without hearing both the parties, they simply gave a decision. Okay, writ is supervisory in nature and thus High Court cannot review findings of the lower court. Some kind of problem means it can be applied. If error is evident, it's very much clear that yes, mistake has happened, right? In order to correct, in order to cure such mistakes, we have the writ of certiorari. Okay.
Yes, ma'am.
So the last one that we have is Q Warranto. We will see it. The literal meaning of the term Q Warranto means by what authority. Okay, what is your authority? Court is going to ask that question in case of Q Warranto. Supreme Court issues this writ to prevent illegal. Okay, when there is a public officer or a person, that person is not having authority, but still he does something. Their court would ask, what is your authority? How have you done this certain thing? Though through this writ, the court inquires into legality of a claim of a public officer. Okay, sometimes it might happen that it says in order to become a principal of a certain college, you need maybe a post-graduation degree. You need 10 years of experience. Okay, in order to become a principal, you need maybe 10 years of experience. Then only you can become a principal. Just an example. Okay. And you have seen that in your college, principal is having only 5 years of experience. Okay. And you filed a case of Q Warranto before the court. And court comes to know that, okay, this is what has happened. Ideally, 10 years of experience is needed. But this person is having only 5 years of experience. How come he is acting as a principal? Okay. So court would first of all ask that person by what authority. Court would ask him to give reasons that how come you are holding this position? How come you are a principal with 5 years of experience? Because maybe some exceptional rules might apply, right? The person may say that, okay, because I have some maybe sports quota, this qualification, that qualification, so I am entitled. Even if I have 5 years of experience, that is enough. That kind of a situation might happen, right? So under Q Warranto, court would ask, what is your authority? How come you are holding this position? How come you have done this certain thing? And the other party needs to give a reasoning. If court is satisfied with the reasoning, fine. Otherwise, court would pass some order that you are not entitled to continue as a principal. You don't have the qualification or something. Okay, is it clear?
Yes, ma'am.
So court would basically ask, what is your authority? How are you holding this position? Or how have you passed this certain order? Okay, that is what it is. Now we have this case where the court held that a private person may file an application for Q Warranto. It is not required that the person is personally affected or interested in the case. Like if somebody is holding a position of principal, a random person can also file. It's not needed that he is willing to get that position. He wants to be a principal or he is a student of that college or something. That is not needed. Any person can file the case. Any person can bring it in notice of the court. Okay, so when we talk about this different types of writs, it's a very important power which is given to the Supreme Court as well as the High Courts, as it provides us remedy and it provides us protection for our fundamental rights. Okay, so importance of writs are very much needed, and it talks about 5 different situations where different types of writs may be applicable. Okay, habeas corpus, when someone is illegally arrested to have the body. Mendemus, when public officer is not performing his duty, court would order him. Prohibition and certiorari applicable in court cases. Prohibition is pending cases. Higher court would prohibit the lower court from continuing it. Certiorari is for decided cases. Higher court would say that this decision is not binding or not valid. Q Warranto, what is your authority? How come you are holding this position? Or how come you have passed this order? Okay, is this part clear? Any doubt, any point?
No, ma'am.
Hey, before we continue, I wanted to inform you about my live mentorship program for LLB students or law aspirants. Law subjects and law topics need detailed clarity. We get that with the help of cases, examples, and detailed explanation. It's definitely not possible to include everything in these short videos. If you find my videos easy to understand and you are looking for some professional help in preparing for your examination, you can join my live mentorship program. Here you will be getting exam tips, answer writing skills, detailed notes that you can refer for your examination, cases, examples, and in a very easy way topics will be explained. I have live classes going on for a lot of subjects as of now. To know more about it, you can drop me a message on this WhatsApp number. I'm also helping a lot of students in writing their assignments. If you need any such help or for any queries, any suggestions, you can drop me a message on this WhatsApp number. And now let's continue with our video.